Good morning everyone, my name is Ritesh and today we'll discuss current affairs topic, right? And today's topic is Krishna water dispute, right? So it is related to your not just geographical point of view but also the polity point of view. How I will explain this in this lecture itself, right? So first let's talk about what we will discuss about this whole topic itself, right? First we will discuss why this particular dispute was in news, right? Then we'll talk about recusal of judges, right? So this comes under this whole topic. I'll explain this later in the next slide itself, right? Then we'll talk about the key points related to the Krishna water dispute and I'll give you some factual points which is very important for your examination point of view. I'll give you some static point itself as a GK, right? Then we'll discuss the constitutional provisions which relate to the dispute of basically interstate water disputes, right? We'll discuss that too. And then we'll discuss the Krishna River. Why? Because this river is the main contentious issue behind so many states which revolves around the same, right? So these are basically the overview of this whole topic, that what we will discuss in this basically lecture itself, right? So let us start with the topic. First, let's discuss why this particular thing was in news, right? So recently, two judges of Supreme Court have recused themselves from hearing a matter related to the distribution of Krishna water dispute between Andhra Pradesh, Telangana, Maharashtra and Karnataka. So basically, Krishna water dispute was there between it was going on between Andhra Pradesh, Telangana, Maharashtra and Karnataka. They all comes in these part of the map, right? If you consider this India as a map, so this is the contentious issue, right? So this dispute actually was going on between these states itself, Andhra Pradesh, Telangana, Maharashtra and Karnataka, right? So this comes to the Supreme Court judges, and two of the judges of the Supreme Court, they said they recused themselves from hearing this matter and they cited a reason for the same, right? So what was the reason? The reason was that they did not want to be the target of partiality because the dispute is related to their home states, right? So there's a term called conflict of interest, right? So this comes into play that because this dispute was related to these states and these states are the home states of these judges, so they don't want to be partial in these kind of things. They don't want to be partial while deciding the case which relates to the Krishna water dispute. That is why they recuse themselves from hearing this dispute itself, right? So this was the reason why this particular thing was in news again recently, right? Now let us discuss what is basically the recusal of judges. What does it mean, recusal of judges, right? So it is the act, recusal of judges is the act of abstaining from participation in an official action such as legal proceeding due to conflict of interest of presiding court official or administrative officer, right? So basically, recusal of judges, it means the act of abstaining from participation in an official action, right? Official action means such as in this case it is a legal proceeding. And the reason is because due to the conflict of interest, because in this case it was the reason was that they think that the dispute was related to their home state. That is why they don't want to be partial in these kind of dispute, right? And this is the whole meaning. That's the whole meaning which we can say that recusal of judges mean, right? So this is what recusal of judges mean, that they don't want to be partial in such kind of thing, right? That is why they cited the reason, right? Now, there are no formal rules governing recusals, although several Supreme Court judgments have dealt with the issue. Now, there is no such kind of formal rules for the recusal of judges, but there are so many judgments of Supreme Court which dealt with these kind of issue, right? So, if we, for example, I'm just giving an example, if you consider as arbitration, if you consider arbitration, right, as an ADR as a topic, right? So there's so many judges which use this kind of thing. There's a conflict of interest, impartiality on such kind of judges, that okay, they are involved in some kind of things similar things, so they don't want to hear such kind of things, right? So they use this conflict of interest clause, that okay, because of the conflict of interest they don't want to participate in such kind of things, all right. So again, if you consider a recusal of judges here, so the point I'm here trying to make is that there are no formal rules there governing the recusal, but there are judgments, Supreme Court judgments, which dealt with the same issue, right? And that's where we derive some kind of conclusions about the recusal of judges, how it formed, and what can we do, how these judges can implement such kind of things in near future also, right? So let's go back to the case itself. So in Ranjit Thakur versus Union of India, this was the case in 1987. So in Ranjit Thakur versus Union of India, 1987, the Supreme Court held that the test of likelihood of bias is the reasonableness of the apprehension in the mind of the party, right? So it means that the likelihood of bias, right, in the basically the biasness comes from the judges, right? That is why they have used this recusal of judge. They have used this term that they because this dispute is related to their home states and due to the partiality. So the likelihood of bias, where it comes from? It comes from the judges itself, right? So it is the reasonableness of the apprehension in the mind of the party. So they don't want to indulge in such kind of things where the party itself think that the judges will be favorable to one party or the other, right? So it is in the mind of the party itself that there must be some kind of biasness in the judgment of the same, right? And in this case, that is why judges, before hearing the issue, they provided this whole clause that okay, the parties must not think about the whole issue, that we will be biased towards some other thing. So they just went away with this issue, right? So Ranjit Thakur versus Union of India is the case where Supreme Court held this issue, and they said the likelihood of biasness, what does it mean and where it comes from, right? Then the judges need to look at the mind of the party before him and decide that he is biased or not, right? So in this case also the Supreme Court says that the judges, firstly the judge must look at the party, right? Before even his idea or even his presence, he must look at the party itself and then decide whether he is biased or not, right? And in this case itself, you can deduce that how these judges, even before starting the dispute, have recused themselves, right? So again, this is a very simple basically thing. This is just a new term for you. Otherwise, it is very simple, right? Now let's talk about the key points of the whole topic, like Krishna water dispute. Let's talk about the issue again. So in this thing starts in 1969. In 1969, the Krishna Water Dispute Tribunal was set up under the Interstate Water Dispute Act 1956 and presented its report in 1973. Now, if you are talking about this issue, now see, this recusal of judges, it is the polity issue, right? Again, it is a polity issue. Now, what we are talking about, Krishna Water Dispute. Now it becomes your geographical issue as well as polity issue, right? How geographical issue? So the state comes into play, the geographical, the Krishna River is there. So again, the rivers, adjoining areas, right, where it comes from, what kind of soil, and all the geographical issues revolve around the rivers will be the priority. And then how it becomes a polity issue? Why? Because the tribunal formed, right? The Interstate Water Dispute Act comes into play. So again, these things merge into this topic. So it becomes both geographical as well as political issue, right? Now, again, just for you to remember the date-wise thing, in 1969 again, the tribunal was set up. So you have to remember the date, 1969, the tribunal was formed about the Krishna water dispute. Then it presented its report in 1973, they presented the report, right? And the tribunal was formed under the Interstate River Water Dispute Act, right? And it is in the year 1956 itself, right? So now I was talking about the first report which happened in 1973 and all. Now the second Krishna Water Dispute Tribunal instituted in 2004. So 2004 again a tribunal was formed. This was the second Krishna Water Dispute Tribunal. It formed in 2004. Now it delivered its report in 2010, right? So they delivered their report in 2010 again. Now what report says? They made allocation of Krishna water at 65% dependability and for surplus flows as follows. 81 TMC for Maharashtra. So basically the report distributed the river of water into these states, right? So Maharashtra, Karnataka, Andhra Pradesh were the states which derive benefits of the Krishna water river. Basically the benefits of the Krishna river were derived by these states, right? Maharashtra, Karnataka and Andhra Pradesh. Obviously Telangana was formed after that, so they also derived the benefit from these things, right? So again, if we consider as a year wise, 69 and 73 is important, then 2004 and 2010 is important, right? And the states which are getting benefit from these things are very important, right? Then after that second report and the recommendations of the report, the Andhra Pradesh challenged it through a special leave petition before the Supreme Court in 2011. In 2010, the report became infunctional. They have said that okay, the water will be distributed among these states. But after a year, Andhra Pradesh challenged the whole thing, the whole basically they challenged the whole tribunal recommendation, right? So it was challenged in the Supreme Court in 2011 by Andhra Pradesh, not Maharashtra and Karnataka, but Andhra Pradesh, right? Now again in 2013, the Krishna Water Dispute Tribunal issued a further report which was again challenged by Andhra Pradesh in the Supreme Court in 2014. Now again, come back to this slide itself, just look at the slide. In this, you only have to remember year and how it forms. So 69, then 73, then 2004, then 2010, then 2011, then 2013 and 14. So this is basically 1, 2, 69 first tribunal, 73 first report, 2004 second tribunal, 2010 second recommendation, basically second report, right? Then 11 Andhra Pradesh challenge, then 13 again a further report was established, but again in 14 Andhra Pradesh challenged that again in Supreme Court, right? Now key points with relate again this. After that there was a creation of Telangana from Andhra Pradesh. Now it also becomes a big issue. Now how you will distribute the rivers of basically the water of Krishna River in these states again, right? Because it was it was given to Maharashtra, Karnataka and Andhra Pradesh. Now Telangana was carved out from Andhra Pradesh. Now how will you distribute it? It becomes a serious issue, right? Then Andhra Pradesh, after the creation of Telangana, Andhra Pradesh asked that Telangana be included as a separate party at the Krishna Water Dispute Tribunal. Now Andhra Pradesh takes a stand that okay, you were giving water to 3 states, Andhra Pradesh, Maharashtra and Karnataka. Now after the creation of Telangana, they want Telangana to be a fourth party of this tribunal, right? Why? Because this becomes a separate state, right? So Andhra Pradesh stand was very clear that Telangana ko include kar do as a separate party at the Krishna Water Dispute Tribunal, right? Then they said allocation of Krishna waters be reworked among 4 states instead of 3. Obviously there are 4 parties now. So they rely on section 89 of the Andhra Pradesh State Reorganization Act, right? And it is clarified that the project specific awards already made by the tribunal or before the appointed day shall be binding on the successor states. Now they clarified that the project specific awards which were granted and which were already made by the tribunal or before even the appointed day shall be binding, which it will be binding on the successor states. Even the states, Telangana even be a party to this tribunal, but it will be binding on all the successor states, right? Now let's talk about the constitutional provisions, which is now again it comes back to the polity issue, right? Now the constitutional provisions which are related to the Krishna water dispute, right? So Article 262 of the Constitution provides for the adjudication of interstate water dispute, right? So Article 262 of the Constitution talks about the adjudication of, if there is a dispute of the interstate water river, you have to consider Article 262. And if you are even reading this topic, you have to remember Article 262 because it is related to the adjudication of interstate water dispute, right? Now, what Article 262 says? Now, it says that Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution and control of waters of any interstate river and river valley, right? So, this is Article 262 which talks about the whole interstate water dispute issue. Right. Then Parliament also enacted 2 laws regarding the same. Which are the 2 laws? The first one is the River Boards Act 1956 and the second one is Interstate Water Dispute Act 1956, in which we are reading this whole topic, Krishna water dispute. It comes under the interstate water dispute. Again, why? Because there are different states that are involved in this topic, right? That is why we are considering this. Now coming back to the first act, the River Boards Act. Now the River Board Act provides establishment of river boards by the central government for the regulation and development of interstate river and river valleys, right? So the first act itself also provides establishment of river boards by the central government. And what work they will regulate, they will develop the interstate water river and the river valleys. They will try to develop these kind of things and they will try to regulate these kind of things in a easy way, in a good manner, in a reasonable thing, right? Now, the Interstate Water Dispute Act, which was in 1956, empowers the central government to set up an ad hoc tribunal, which we were talking about. So, Krishna Water Dispute Tribunal, it was instituted under this, right? So, this act empowers the central government to set up an ad hoc tribunal for adjudication of a dispute between 2 or more states in relation to the water of an interstate river or river valley. Obviously, now River Boards Act was completely doing this other thing, right? But if you are talking about Interstate Water Dispute Act, they talked about the setting up an ad hoc tribunal which adjudicate the dispute, right? If the states are having dispute between the rivers, right? So they'll go under this act, they'll go under the tribunal, they will settle the dispute under this tribunal itself, right? And the constitution and the setting of these kind of tribunals comes under the Interstate Water Dispute Act, right? And in this, neither the Supreme Court nor any other court is to have jurisdiction in respect of any water dispute which may be referred to such a tribunal under this act. Now, Supreme Court or any other court will not have jurisdiction in this. If you are going under this tribunal, then this tribunal has the sole authority to decide the case, right? So, this was all about the constitutional provision of this act. Now, lastly, let's talk about the Krishna River, right? So again, this is a static topic. Last slide, it is strictly static, right? So Krishna River, source, what is the source of Krishna River? So it originates near Mahabaleshwar, Satara in Maharashtra, and it is the second biggest river in peninsular India after the Godavari River, right? So again, this is important. Just remember the origination of Krishna water. Why? Because it is a current topic, Krishna water dispute, and so you can expect question from the respective topic itself, right? Source is important. Then drainage, it runs from 4 states, right? Maharashtra, North Karnataka, and the rest Telangana and Andhra Pradesh. And before it empties into the Bay of Bengal, so it drains into the Bay of Bengal itself. Now, the tributaries Tungabhadra, Malaprabha, Koyna, Bhima, Gatraprabha, Yadla, Varna, Dindi, Musi and Dudhganga. Now, tributaries are not very important for you, right? But drainage and source is very important for you. This was all about this whole topic, right? Krishna water dispute and the recusal of judges in this whole topic. If I summarize the whole topic, the point you need to memorize for your examination point of view is what is basically recusal of judges, right? And the states involved in this dispute, right? Then the tribunal forum, right? How these 4 years, how in these years they formed, right? So again, the years are very important. Then the key points related to the whole topic about the creation of Telangana and the tribunal itself, right? Then the constitutional provisions is important. 262, you have to remember the two acts that support the same, River Boards Act and the Interstate Water Dispute Act, right? So again, these are the things you need to remember, right? So thank you so much for this topic.